Doesn't item 26 show prior knowledge of who was paying the attorney's fees? Let's see here. Yes. Okay, let's look at that. I'm glad you pointed this out because I kind of quickly went through here. Let's bring that up. Plaintiff should not be allowed to introduce evidence of who is paying for legal fees because such evidence is not probative. We talked a ton about this. I can't believe I skipped it. Thank you so much. This is why you guys are awesome and part of the channel, part of the community, and why I legitimately mean it when I say you make the videos better. Because it would not have been as good of a video without this. I would have missed it, which is me dropping the ball. All right, plaintiff should not be allowed to introduce evidence of this. The identity of the payor of attorney's fees is not relevant to any of the issues in this case. It does not intend to make any material fact more or less likely. Evidence of Amber Heard's insurance coverage and the insurer's payment of attorney's fees therefore should be excluded. Ding, ding. The insurer is paying the attorney's fees. Again, should not be allowed to introduce evidence of who's paying each side's legal fees. In addition to being wholly irrelevant, evidence of who is paying each side's legal fees should be excluded because any probative value is substantially outweighed by the danger of unfair prejudice, likelihood of confusing or misleading the jury. And then here's the cite. Here, evidence of who is paying attorney's fees for each side is unfairly prejudiced and is very likely to confuse or mislead the jury. Granting this motion in limine because reference to the defendant's insurance coverage could prejudice the defendant or mislead the jury should not make its verdict based on the liability and damages facts, not based on knowledge of coverage. Evidence of collateral facts, which is insurance, from which no fair inference can be drawn, tending to throw light upon the particular facts under investigation, is properly excluded for the same reason that such evidence tends to draw the minds of the jury away from the point in issue to excite prejudice and mislead them. So glad you brought this up because I did want to talk about this. So this is how it is in every case. We're not allowed to talk about when the insurance company is paying for all these lawyers, all these experts in our cases as well, because they say it could prejudice the jury, which is fine. Okay, that's a rule. I think it's unfair, but it is what it is. You better believe that if a defendant sat up there and said, I have to pay all these legal fees, feel sorry for me, there would be sanctions. There would be a mistrial if we wanted it. I guarantee a judge would grant it here. I don't think a judge would give me a curative instruction to say, actually, judge, let's tell the jury the insurance company is paying for it. I think the judge would offer me a mistrial or some kind of other curative instruction like the defendant didn't actually pay the attorney's fees, but never are they going to let us say the words insurance company in a trial. But very interesting that they literally wanted to hide this. And then they literally, I hate calling people liars, but they literally lied about it saying Amber had to pay these attorney's fees and that's why she went bankrupt. Now, I think they can argue that she had to pay some of them because I think there is some discussion about her having to pay some of them. But I think they said she paid $6 million, which was just false.
But then she got sued here and hasn't been able to because she spent $6 million in attorney's fees. That is
I hope so.
She still intends to pay.
You calling me a liar?
I ain't calling you a truther.
Objection, Your Honor.
That doctor has testified to that.
So normally you don't want to object during closing arguments because it's a real dick move.
But you can't let opposing counsel lie.
Right. If there's a blatant misrepresentation of fact or law, you have to object. Notice they did not object during David Rottenborn's or Ben Rottenborn, whatever. They did not object during Rottenborn's closing argument at all. They have no desire, no seeming desire to just be a dick and interrupt. But Elaine is misrepresenting facts and law, and she's lost every objection so far. We'll see what happens here. But I mean, she clearly lost the last one. She had to go correct her representation to the jury.
I wasn't just saying what I was just saying to you, but
I am saying it, just not in that way, but in a different way that makes it okay for me to say it. I would never say.
Johnny should just get up and bitch slap Elaine. That would be funny.